Dude, this is so bad. I hate to make a joke out of this because it's a really fucked up situation. But this is called I reboot the Drake and Jocks. I can't even. Drake and Jocks. What is wrong with me? I reboot Drake and Josh by adding a laugh track to Drake's guilty plea. I like the touch with the. Is this actually a logo? The foot from Nickelodeon? Because like Dan Schneider, I think that is like a weirdo. There's so many weirdos who apparently worked for Nickelodeon. Because this is one of them, man. And I think it's important to acknowledge that like he himself, like, he didn't get charged with anything related to like, you know, physically interacting with a kid. But the person definitely alleged that he did. It just wasn't part of the lawsuit. But still, it just doesn't make sense that a 30-year-old man would have anything in common with like a 15-year-old girl. I always say that because I feel like it's not like, I understand that he's an older guy and like he works, like he does stuff for kids, right? Because he like worked for Nickelodeon, so he has like teen or kid fans. But it doesn't excuse that you would associate yourself with like children. The only time you as a 30-year-old should be associating yourself with a 15-year-old, maybe as a celebrity, is if there's another celebrity that's within your sphere that's young, but you never get like a personal relationship. It's just so weird. Like, people really, you just keep in mind, like, there's nothing that a 15-year-old and a 30-year-old have in common. It's so weird. Let's watch this.
Okay.
This is terrible. That's true, they have feet in common, you're right. These guys are so dumb. I don't think I've ever watched like the video.
We're hearing, excuse me, case number 659324, State of Ohio versus Jared Bell. Defendant is appearing by Zoom. Mr. Bell, can you hear the court?
I can, yes, Your Honor.
Very good. Counsel for Mr.
fuck?
Bell is in the courtroom. Ian Friedman and Madeline Grant, present from the state. Kevin Brigman also in the courtroom. My understanding, there's been a plea agreement reached where the defendant will plead guilty to count one, attempted endangering children, a felony of the 4th degree.
I'm so sorry for
Guilty to
laughing.
count 2, disseminating matter harmful to juveniles, misdemeanor of the 1st degree. Correct statement, counsel?
That is correct, Your Honor.
Mr. Bell, how old are you?
Currently 34.
How far did you go in school?
GED.
Why is
Are
that?
you present?
I'm sorry, but the laugh track really does trigger like a psychological response to make you want to laugh, and it's really fucked up.
Only under the influence of drugs, alcohol, or medication?
No, sir. No, Your Honor.
Are you undergoing psychiatric treatment?
I mean, I've seen a psychologist. I don't know if that's psychiatric treatment.
Bro, I don't know. Like, you should be.
Maybe answer that, sorry.
Okay. You understand what we're doing here this afternoon, is that correct?
I do, Your Honor.
Very good. Felony of the 4th degree, attempted endangering children, carries anywhere from 6 to 18 months in prison in monthly increments and/or a fine of up to $5,000. Prison time is not mandatory. However, if you go to prison upon your release, you could be subjected to a discretionary period of 3 years post-release control. Post-release control could involve restrictions on your activities. If you were to violate those restrictions, you could be returned to prison up to a maximum of 1/2 of your original sentence. A misdemeanor of the 1st degree carries up to 6 months in county jail and/or a fine of up to $1,000. Do you understand the potential penalties?
Why is there
I do, Your
a laugh
Honor, yes.
track there?
Do you understand if you plead guilty, that is an admission by you that you did these crimes?
Yes, Your Honor.
Even though your lawyer may have discussed your rights at trial, it's my duty to explain them to you in open court. First, you would have a right to a trial by a jury or by a judge without a jury, whichever you prefer. You'd have the right to be represented by a lawyer. If you can.
Sorry, do you know, for reference, which something I think is interesting is that the young girl she's now 19, but she was, I think, 15 or 14 at the time this happened. Maybe 14, 15. She called him a coward for not showing up to the court. He kept doing like web showing up, and like I think it's something to note because this guy is obviously a fucking coward.
Not afford one, the court would appoint one to represent you at no cost. At trial, the prosecutor would have to produce its witnesses in open court, and you or your attorney would have the right to cross-examine those witnesses. You could issue subpoenas to compel witnesses to come into court to testify on your own behalf. You could testify if you wish, but you could not be compelled to testify against yourself, and the prosecutor cannot comment on your failure to testify. You'd be presumed innocent until the prosecutor proved your guilt by evidence beyond a reasonable doubt. Do you understand those rights?
Yes, Your Honor.
Have any threats or promises been made to you to induce this plea?
No, Your Honor.
Are you satisfied with your lawyers?
Yes, Your Honor.
Are you presently on probation, parole, or post-release control?
No, Your Honor.
Having said that, how do you plead to count one? Attempted endangering children, felony of the 4th degree.
Guilty?
How do you plead to count two? Disseminating matter harmful to juveniles, 1st degree misdemeanor.
Guilty?
Let the record reflect defendant has
What the
pled guilty.
fuck,
The
dude?
court accepts that plea. Finding was made knowingly, voluntarily, and intelligently. Sentencing is going to be deferred till July 12th at noon. The victim can provide a victim impact statement if she wishes, either by herself and through Zoom or through the witness victim advocate from the court. Additionally, counsel can file sentencing memorandums as well. Please do it at least 3 days prior to July 12th. Anything further, counsel? Very good. We'll see you July 12th. Thank you.
Oh my god. That was so bad. That was ridiculous, dude. That was so bad.